Okay, so there was a recent comment about the presumption by somebody who might not be familiar with the definition of being disabled under the SSA programs. The question of whether, well, if someone can work, doesn't that mean they're not disabled? It's the devil's in the details. And the question is, what is the definition of being able to work? Is being able to work, are you able to work if you can do something that would pay money, but you can only do it for a half hour a day? Would that be an occupation that you can do that would make you not disabled under the rules? So I say this because when someone says nobody should be asking about or filling out an 820 or an 821 form about work activity while they are claiming either a pending disability claim or a past one that they prevailed on and they're now collecting, because sometimes you have to fill out these requests at either one of those times. Well, I guess the person hadn't looked at the definition of disabled. And every policy, be it SSA, a worker provided disability policy, a privately purchased one, because we can do that too, each of us, if we feel we can afford it. They all have their definitions of the various policies of what constitutes being disabled that would trigger benefits. So under SSA, the Social Security Act, and all the rules and regs within, being disabled means being unable to perform, and this is kind of roundabout, unable to perform a full-time occupation, an occupation on a full-time basis, on a sustained basis, which means week after week after week, month after month, for probably at least 6 months. And if you can't perform full-time, but you can perform something less, then you can still be disabled because you can't do full-time work. It doesn't mean, like this person may have thought, that you have to be bedridden, that you have to be in a coma, maybe confined to a wheelchair and have no arms. I don't know, but the confusion of, wow, if you are filling out an 820 or an 821 form, and just to refresh you, those are forms about work activity. The 820 is about self-employed activity that you've advised the SSA of, and the 821 is employee, when you work for somebody else and get a W-2. And that why should you even be filling them out and filing for disability? Because they mean you're working. Well, no, they don't mean you're working substantially. Remember, substantial gainful work, full-time work. So I just wanted to make sure that was clear. I know it's easy to get judgy, right? We all do it. Most of us probably kick ourselves later. We're just human. But if you look at somebody, and I bring this up because I see people being super judgy about what they don't know about disabled people who you can't see a billboard sign on their forehead telling you what their disability is, and they seem to be walking fine and don't have, 3 arms or 10 legs or 4 tails. So I hear a lot of people say, well, my neighbor collects disability and he's fine. I see him in the grocery store. Well, the ability to go into a grocery store does not mean you're able to work an 8-hour day, does it? It doesn't, There's a whole lot of pieces of evidence that would go into whether someone's activity while they're not working and claiming disability and have a pending claim, whether that would be sufficient evidence to show that they actually could be working outside, in the workforce at some job. Now, remember the jobs, when I was alluding to the definition of you have to be unable to perform an occupation on a full-time basis and also on a sustained basis, which means durational. It also can't just be your one-off job. It can't be that job. If you can do that job that there's one of them in the whole country because your brother-in-law offered to hire you for something, and you could do that job, but it turns out you're not. Or if you are, you're only collecting under SGA and your medical evidence clarifies that you could not be doing it full-time, or you maybe could be doing that job full time, but that job does not exist in substantial numbers in the national or regional economy. Therefore, it is not a job that is considered when they're deciding whether you can work full time. Because think about it, then everybody who is disabled would lose because there can always be a job manufactured. Just one, that's all you would need is one over there. Well, Johnny could go do, Johnny's in a coma, but we could make a job for Johnny. He could be, a prop, it's ridiculous. So the jobs have to exist, and the SSA recognizes this. It's in the law that the jobs have to exist in substantial numbers in the regional or national economy. And when I say regional and national, the important regional or national, I still got my cold, but it seems a little better today. Is that if someone says there is none of those jobs in my area, that's not going to, if there is jobs across the country in substantial numbers, you will lose on that basis, because the idea isn't that you should be able to just walk out your door and if you can't find a job that you can do there, you prevail. No, because like throughout all the history of mankind, people move to get work, to sustain themselves. Some people move to a warmer area because cold air is bad for them. Some people move to a city because all the jobs that they want to get are in the city. It could be anything like that. But you cannot prevail if there's substantial jobs in either or both the regional or national economies, because you're not supposed to be handed it on a platter. That's not what we're entitled to. We're entitled, and that might not be the right word to use because you're not really entitled until you are, but technically we would be eligible if we are unable to do a job that exists in substantial numbers. So not that one-off job, not that miracle little job that the brother-in-law created for you, but a job that exists naturally in substantial numbers in the local or regional economy. Local, regional, or national economy. Which brings up a point like, well, which jobs? How do you know which ones exist in substantial numbers in either the regional or national economy? This is a big subject of debate because the authoritative source upon which the SSA largely relies is the Dictionary of Occupational Titles and what all it says and related resources that vocational experts use to determine how many of those occupational jobs exist in the national or regional economy. And because that has largely not been updated for decades, I mean, it's kind of nonsensical. Everybody knows it. The media just recently this year, in I think 2023, one outlet wrote about it, and now suddenly everybody knows because it was a major media source. Of course, I say, well, then why didn't you say this before? We've known this for forever. We've been saying it forever. Like, come on, you got to get this updated. That job does not exist in substantial numbers. I mean, there's some really ridiculous ones. Maybe we'll have to go through a video maybe and point them out and make fun, poke a little fun. But the authority is a little off. But unfortunately, we kind of have to deal with it. But by and large, we can argue a little bit, but it doesn't necessarily hold water because they're kind of bound to what they're bound to. So the battle gets a little deeper than that when we're in a hearing, for instance, and trying to prove that to the vocational expert, a hypothetical person, that job would not exist in substantial numbers that you indicate it does. And that might be a losing battle at times, but so that's not really where we put all of our efforts in a case for sure. But I do hope they update their resource for what numbers, you'd think it's out there. I mean, I think in our tax returns, we have to say what industry we're in, right? Our occupation. So I think they could do a little better with this, but they don't put money towards it because, we have no money. No money goes anywhere. We just don't have it. Yeah, it's going someplace. It's just not going there. All right. Anyway, so yeah, a person who is filing for disability or is collecting disability is more than legally able and factually capable oftentimes of working a little bit to earn some money and increase the standard of living, good for the self-esteem, getting out and about. I think it adds longevity to the life as well as quality to the life. And if you were one of the misguided people who thought, well, if you're filing for disability, you shouldn't be, uh, why would you even be working and having to report part-time work? That means you're not disabled. Couldn't be more false and unread. So I'm sharing this with you. So whoever thinks this now knows that that's not the case. And just like if you are disabled or become disabled, you might very well be legally disabled, even though you're not relegated to a bed full time. You can actually get up on your feet and maybe do a 2-hour shift and earn yourself some bucks. There's many ways to skin that cat. And the SSA actually encourages people to get out there and further their lives and gives you the direct guidelines. They explain it somewhat clearly, even though it's a little complicated. I don't think their explanations are complicated. There's just different rules at different times of how to stay within the rules while working while collecting disability and being disabled. So we know for a fact it is not true that you have to be unproductive and relegated to a bed or confined to home and not be able to do anything productive of the most mild nature to be disabled. And yes, you could therefore you'd be getting an 820 or an 821 just to keep it all above board, and so they can keep an eye on it and make sure you don't increase those hours or that income so that it is Otis. That's Otis. You can't see him unless I were to pick him up, maybe. Should I try? He's crazy. Let me see. You want to try? Oh, come here. Oh, come here. Oh, come say hi. Oh, come here. All right, Chubby, come on. Say hi. Yeah, no, can you look up there? You can't even see the screen, can you? The cat can see it. Look there. There's Otis. Otis. That's Otis. He's a miniature Australian Shepherd. He's neurotic. He's overprotective. He doesn't listen. He has bad trainers here at home. He's my daughter's dog. Anyway, and he jumps up and licks your plate. So welcome to my world. Anyway, that's it, guys. Talk to you later. Bye now.